All right. Hello and welcome. Hello and welcome. Thank you so much for being here. Welcome to another episode of the Empowered Immigrant Live today. Today we're going to be talking about the new Good Moral Character Memo. Came out less than a week ago. Came out last Friday, I believe, on the 15th of August. So we're going to be talking about Trump's latest change, Trump's latest Good Moral Character Memo, and how that affects you if you're applying for citizenship or if you're about to apply for citizenship. And so welcome. Thank you so much for being here. My name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. And remember, the Empowered Immigrant Live is here to train, teach, inspire, and empower immigrants to make the most out of immigration laws and to make the most out of their lives. All right? Today our theme is to discuss the new Good Moral Character Memo that just came out. It's less than a week old. And, are you thinking of applying for citizenship? Or are you thinking of applying for a green card or asylum or a U visa or VAWA or some kind of immigration benefit? Or are you just wondering what's the best strategy in your situation to up-level your life through immigration law? Because if so, go for it, do that, and I'd love to help you with it, okay? My firm is on a mission to win 10,000 immigration cases in the next 10 years. We would love for your case to be one of them. So today we're talking about Trump's latest Good Moral Character Memo. This is a memo. It was released last week. We'll get into that. And if you're tuning in right now, welcome. Thank you so much for being here. Really appreciate each of you. Whether you're on YouTube, Facebook, LinkedIn, Instagram, TikTok, thank you all so much for being here. We are live, folks. I'm recording this. It's the 21st of August of 2025. And so welcome. Thank you so much for being here. There's so many changes are happening, all right? And the changes just keep happening. And, we're in August of 2025. We're just 8 months into this new administration, and lots of things have happened. I'm going to jump right in to this memo, and then I'll open it up for questions. And so if you have questions about your case, feel free to submit them. I'll do my best to answer them right here, right now, live. Okay? I do have another commitment at 11 a.m., and so I need to be intentional with my time. But if you have questions, please feel free to think that through and send it over. Okay? So this new memo, GMC, or Good Moral Character Memo, it came out on August 15th, all right, which is not even a week ago. And it affects people who are applying for citizenship, okay? So first of all, I got to explain, right? This is a memo. It's a policy memo. It's policy guidance within USCIS. It is not a change in the law, all right? Congress has not done anything about this. This isn't like earth-shattering. This isn't like a total change in the law. Citizenship and naturalization laws have always required that a person establish that they are a person of quote-unquote good moral character as part of the requirements to win citizenship, all right, to win naturalization. But what is a change is, in the past, we have been able to point out that our clients haven't done anything bad, all right? We've been able to point out that our clients have committed no crime and owe no tax obligations that they're behind on and don't owe child support, etc. We've been able to point out that our clients have not done anything bad, as opposed to having to demonstrate all the good that they've done. All right? Should I say that again? In the past, we've been able to point out that our clients haven't done anything bad to demonstrate that they're a person of good moral character, instead of having to demonstrate all the good that they've done. Got it? I'll say that one more time. In the past, we've been able to point out that our clients didn't do anything wrong. And so therefore, they're a person of good moral character. Not anymore. Trump is now saying that we've got to demonstrate that they indeed are a person of quote-unquote good moral character. Not perfect moral character. All right? You don't have to be a saint to become a U.S. citizen. You have to be good as defined by the community values, community guidelines. All right? This is an ambiguous term that immigration officers are empowered to apply in a naturalization interview. Got it? So what does this mean in practice? What does this mean in practice? In practice, it means that when you submit your N-400, your request for naturalization, you should at least include some evidence, all right? Some evidence of the good that you've been doing. It could be a declaration from yourself. It could be a declaration from people in your family or in your community. The memo that was released says, for example, you should demonstrate sustained community involvement and contributions to your community in the United States, right? Or, for example, that you are caregiving for your family and that you have long ties with your family in the United States. Or, for example, your educational attainment, right? If you went back to high school or college or got a degree or whatever, right? You're studying English or you're studying something, some trade, you could include that, all right? The memo says, for example, evidence that you have had stable and lawful employment history. All right, two more. It says evidence of your length of lawful residence in the United States. All right, and it says, finally, evidence of compliance with tax obligations. You've been paying your taxes. All right, and so it's just a way for the government to ask a little bit more of people as they're going through the citizenship process. This should just be for the past 5 years, because it's a 5-year rule. 3 years if you're living in marital union with a U.S. citizen, all right, but otherwise 5 years. And so the way I think about this is we want to maximize your chances of winning your case. And so you'll want to include something, all right? Include some evidence of the fact that you are a person of good moral character. Got it? That's what this memo is saying, all right? The best advice whenever you're applying for citizenship, first assess the risks involved, all right? Some citizenship cases can be quite risky, all right? And understand all the legal requirements involved, and gather evidence to meet each of those legal requirements, then file the case. What's the first step always? It's get good advice, get good counsel, have a detailed consultation. If my office can help you with that, we'd love to help you with that. Give us a call. We're here to help. We'd love to help. All right? That's all I got for today. Thank you so much for being here. Now, let me answer your questions. What questions do you have? I see some have been coming in, so thank you for this. So Lamara, I see your question here. You say, what to do if your U.S. citizen child turns 21 and your cancellation of removal case gets denied and it's now pending at the BIA? That's a problem. I'm really sorry about this, Lamara. Thank you for asking it. First of all, you got to know that you are not alone in this type of situation. The problem, though, legally with cancellation of removal is there is no age-out protection. All right? Should I share how frustrated I am about that issue? Okay? There's a law called the Child Status Protection Act that protects and prevents from age-out in certain contexts, but there is no age-out protection at all in the cancellation of removal context. And it's very frustrating. And I wish, it'd be a very simple change, I think, to say, hey, look, the Child Status Protection Act adds to the age of the child the amount of time that the petition was pending in the I-130 petitioning context. It'd be really easy for them to say, hey, that Child Status Protection Act, let's just apply it to cancellation cases. Light bulb, hey, Congress, what a great idea. Unfortunately, that's not the way the legal system is. I mean, the other thing that they should just do is they should increase the numbers of cancellation, right? Because cancellation is limited, remember, to 4,000 grants per fiscal year. And there's a waiting list. I think it's like 5 years right now. Don't quote me on it. I was actually looking for the precise wait list numbers, and I wasn't able to find. I was looking for this recently. So if I get more precise, but I think it's about 5 years right now. And so I think that your case is going to be denied, Lamara. And my best advice there is to see if there's some other avenue, And my best advice would be to see if there's some other avenue before the BIA denies your case, right? Is there some opportunity to maybe do a motion to remand while it's still at the BIA? I'd recommend talking it through with an immigration lawyer. You probably already have one. Talk it through with your lawyer, or if you want a second opinion, etc., feel free to call our office. We'd be happy to help you. All right. There's a question that looks to me like it's written. The writer looks like it's a Japanese name, and to me at least, sorry if I'm incorrect there. And it says, "Can I ask a question for someone?" So type in your question, and I'll do my best to answer it. Okay. And if you want to schedule a consultation to really discuss your situation, then feel free to look at the description below our video, find our phone number, find our website, give us a call. Okay? But thank you for being here. Let's see, the next question I see is from Betty. Betty, thank you for being here. You say, hello, I had a U visa. I left the U.S. in 2021. I could fix it through my citizen daughter. Let me ask you, Betty, because I want to understand your situation. So are you saying you had a U visa, but you don't have it anymore? And then you left the USA in 2021 and you have not come back? Is that what you're saying? Are you currently outside the US? Because it would be really unfortunate. That'd be really unfortunate, right? When a person has a U visa, as long as you have physical presence in the US with a U visa for 3 years, you can apply for a green card, right? And so, but if that's the situation, yes, you might be able to fix your case through your citizen daughter if your citizen daughter is 21, right? But you need to meet the eligibility requirements, and you may have triggered inadmissibility when you left, even if you left with a visa, because you may have had over a year of unlawful presence in the past. So unfortunately, when you left in 2021, you might have, I'm not saying conclusively, we would have to do a consult to figure this out, but you might have triggered a 10-year bar when you left the US in 2021. Okay? And so you want to be cautious, and you'll want to do a detailed analysis, and maybe it was waived, maybe that exit was waived when in your U visa after the exit. You'll want to really look at it. We would run FOIAs. We would do we should really talk it through. If you're currently in the US, then you might not need to fix your case through your daughter. You might just be able to do it through your U visa. Even if your visa has now expired, you can do what's called an extension and then adjust. Anyway, I hope that's helpful, Betty. I'd love to help you if there's any way that I can. Please feel free to contact my office, and we could look into those issues. All right? Mind your own uterus. I was trying to read your, I was trying to read your URL, and thank you for being here. And yeah, very much great. All right, that's a great name. So you came in with an F1 visa, then you got TPS. Your visa expired in September. Your husband's a citizen. He's asking for me. Will I be okay? You know, your name. So my sister, right? My sister works. She's a physician's assistant in a hospital, and this is not answering your question, but I just wanted to share because your name just makes me think of it. My sister cracks me up, right? She works in a hospital. She delivers babies. All right, that's her job, and so she works with like women's health issues all the time, right? And she delivers babies, and she has this mug that she has that says, I think it says like Dr. Carly, her first name is Carly, at your cervix, which is anyway. I thought that was funny. So your situation, let's see. Well, I digress. Let me get back into the immigration context. You came in with an F1 visa, then you got TPS. It expired in September, but your husband's a citizen and he's asking for me. Will you be okay? You know, I think so, yes. I think so, yes. Let me explain why. All right, when you're married to a U.S. citizen, your husband's petitioning for you, there's 3 requirements. First, you have to be lawfully inspected, admitted, or paroled into the United States. You entered on an F1 visa. Second, you have to be in a lawful, bona fide, good faith marriage with a U.S. citizen. So document that you fell in love. Document that you and your husband want to form a life together. This is not just for immigration purposes. And third, you've got to show that you are, quote unquote, admissible. All right? Now, there's a whole slew of hundreds of questions regarding inadmissibility. The top 5 that I like to ask are, have you ever been arrested? Have you ever used, possessed, cultivated, sold, had anything to do with any illegal drug, narcotic, including marijuana? Have you ever lied to the U.S. government in an application for immigration relief, committed a willful misrepresentation of a material fact? Have you ever claimed to be a U.S. citizen before for any reason? And have you helped any other person enter the U.S. without permission? If the answer to those questions are all no, my guess is you're going to be just fine. All right? I don't think that you have any unlawful presence bars. We screen for that too, of course. But it looks like you're probably going to be fine. Anyway, best of luck to you. If my office can help you in any way, I'd love to help you. All right, Aman. Does ICE detain me at random street stop checks? You know, this is a good question. Aman, thank you for asking it. A lot of people are very nervous about this. There's a huge difference depending on where you are, all right? If you're within, for example, 50 miles of a U.S. border, it's much more frequent that Border Patrol stops people or has checkpoints, etc. So that's one thing. ICE throughout the country is different, right? I think that there is more ICE presence in some places and less ICE presence in other places. I see your follow-up question here, Aman. You got a B1, B2 visa. You applied for asylum. You have all the document receipts. You've done your biometrics. You've got your I-94. Okay, I think that the risks of you being detained at random by ICE, in my experience, is very low. All right? In my experience, it's very low. I think you should be okay. I'm glad that you've got your asylum case underway. I'm glad you entered on a B1, B2 visa. You're not subject, I don't know when you entered, that's another detail. As long as you didn't enter within the past 2 years, then you shouldn't be subject to expedited removal anyway. All right? And as long as you haven't committed any crime or arrest or anything like that, you shouldn't be subject to mandatory detention. And so it's like, even if ICE were to stop you, you could show them your receipt notices. And hey, this is who I am. I'm a lawful, you can get a work permit through your asylum case that can actually allow you to get a real ID driver's license, and then you could show that to them, and then you should be okay. Anyway, I hope that's helpful. If you want to talk it through in more depth, then feel free to give us a call, but that's my answer here today. All right, we're doing good, everybody. We're doing good. So thanks for being here. Keep asking your questions. If you're just joining in right now, my name's Otis Landerholm. I'm a certified specialist in immigration law, and I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. It's an honor to be here with you this morning. All right, so let's see. Next question comes from Lenz Roosevelt Lambert. Very cool name. Thank you for being here. You say, what to do when your asylum case was denied after 10 pending years and you are a TPS holder? Okay. Thank you for asking that question. I'm sorry that your asylum case was denied. One question is, was it denied by an immigration judge, or was it denied by the asylum office? Because if it was denied by the immigration judge, you should appeal it to the BIA. If it was denied by the asylum office, then you actually don't need to do anything. You can renew it if you're ever put into deportation proceedings. Okay? I'm glad that you have TPS, because TPS is your plan B. It's your backup. All right? You're still lawfully present in the United States. You still have your work permit, or you should, or your work authorization at least, through your TPS. And and that's the way it is. If there's some other thing that you could apply for, VAWA, U visa, if you're in immigration court, potentially cancellation of removal, etc., then you should think through what's your alternative. But if you're in a situation, a procedural posture where you could possibly appeal the denial, then you might seriously consider doing that. Okay? And I'm sorry to hear it was denied. Yep, I'm really sorry about that. All right, Eat Zedek 102. I see your question here. Thank you for being here. You say, I'm in a process for humanitarian medical deferred since May. Since May. I got it. Since May. How long does it take to get an answer? That is a tough question. I don't know what precisely. You said since May 19th, 2026. That's a year from now. So you're living in the future. You're living in the future. It's not a bad place. I like to think about being the future all the time as well. So anyway, I think that for me, I can't give a precise answer to that without really reviewing what you have requested. Right? It might be like humanitarian parole, but that's difficult. All right, that's difficult. If I hope you have a lawyer that's helping you through that process. If you don't, feel free to reach out. I'd love to get into it with you. All right, I'd love to help you in whatever way I can. Right. Okay, let's see. Brit1234. You say, are they searching phones at immigration appointments in the U.S.? Typically not. I've got a team member at a USCIS appointment here in the U.S. right now, as we speak, and no, they're not searching here in San Francisco, in Sacramento, at the field offices near us. No, they're not searching phones when you go into appointments. It's really Border Patrol, right? It's not so much USCIS as searching phones. At least that's my experience. All right. If there are practitioners in other parts of the country that have seen that, please inform me. But I've never noticed. I've never had a USCIS officer screen somebody's phone history. But they do look at social media. you better believe they have access to your Facebook accounts, etc., and they can search those things. All right, so mind your own uterus. I see your thing there. Again, your TPS expires this September. Okay, that doesn't change the analysis at all, at all. All right, as long as you are those three things, lawfully inspected and admitted or paroled, which it sounds like you were, you are in a good faith relationship, bona fide relationship with your U.S. citizen husband, and you're quote unquote admissible. And the admissibility question, that's where it's good to do a consultation, right? Ask all the questions, right? But as long as you are those three things, then you should be legally eligible. I mean, technically, it's a discretionary application too. So if there's some other problem in your case, then it could be. But yeah, but typically, it sounds to me, just from my brief it sounds to me like yeah, you're probably okay. All right, Manuel Macala, you say, how long does an appeal to the BIA take after filing the brief with the attorney? Yeah, that's a great question. How long does an appeal take to the BIA? You know, I have one case where we briefed it probably 2 years ago, and it's still pending. All right? That is rare. That's uncommon. It's a very complex case. And it was a very good brief. So we're going to see what happens there. We have had, and I have seen plenty of cases where you file the brief and 6 months later you've got the appeal decision. And so a lot is changing at the BIA, though, and so that's my range. In my experience, 6 months to 2 years, but really it's more like probably maybe 6 months to 1 year is much more common. Okay, 6 to 9 months maybe is much more common. All right, Eat Zedek, I see your follow-up there. You said you meant 2025. I understand that. I still would say that if you really want to talk about it in more depth, you have a nuanced situation. It's not common to be able to apply for anything. There's no process called humanitarian medical deferred, right? There is no such legal process. And so you probably have applied for what we call humanitarian parole is my guess. But it's like if you want really to have good advice about it, we should really read what you've submitted because it sounds unique to me, right? It sounds unique to your situation. And so, but I hope it was done well, and I wish you the very best with your process. Absolutely. All right? Cool. I think that's it. I think those are all the questions that I've got. Oh, no, I see one here on TikTok. Would you file an I-130 undocumented as kus? All right, would you file an I-130 undoc, no contact, USCIS, married to a U.S. citizen, 12 years, brought child at 3, now 37. Brought as child at 3, now 37. Would you file the I-130? You know, thank you for asking that. Thank you for asking that. Would you file the I-130? That is a question that requires actual legal advice. I don't want to just say yes or no without really knowing your situation, you know? So that's my actual answer, right? I'm not gonna tell you yes or no to file an I-130 without really understanding your situation. However, the answer is if you're eligible to use that I-130, which I don't know in your situation, we would need to do a consult, right? But if you are eligible to adjust status through that I-130, then absolutely yes, do it. All right? If you're not eligible to use that I-130, then it has limited benefit. And I would say there's probably the benefit doesn't outweigh the risk. Like if you have to consular process, I don't know. I would really recommend do a consultation, think it through, and let's really explore what all the options are for you. And if that I-130 is one of them, then hey, great, let's do it. Okay? If that I-130 really isn't the best path, if it's not really a good option for you, then let's find a different one. All right? That's my best advice. That's all I got here today, folks. Thank you all so much for being here. Really appreciate it. Whether you're on YouTube, LinkedIn, Instagram, Facebook, TikTok, I really appreciate all of you. Thank you so much. And yeah, make it a great rest of your day. Hey, if you are a client of our office, if you are a current client of our organization, we have a client call. This is for clients only, all right? We have a client call today at 3 p.m. Join us. Bring your actual questions about your case, and we'll talk about case strategy. And really, I'm talking about some strategies to defend your rights in immigration court right now. And so join us at 3 p.m. with your questions. All right? Joel Cinto, I see you here on Instagram. Great to see you. There is no problem traveling with the residents to other countries. I can't say that universally, but it's great to see you, Joel. Great to see you. And so, when you have a green card and you're a lawful permanent resident in the U.S., you're also a citizen somewhere else. All right? And so to go to a different country requires on the citizenship laws or the travel laws and the visa requirements of that other country. For example, imagine you're a citizen of Mexico, but you want to travel to Vietnam, just as an example. You would have to look up whether or not Vietnam has like special visa requirements for people from Mexico. And maybe you just have to pay $30 or something to get that visa, and then now you have, travel authorization for 90 days to go visit some other country. Does that make sense? And then the residence, the green card, is what gives you the ability to re-enter the United States. All right? And it's not an absolute right to re-enter, right? But it's a legal document that allows you and says that you're a lawful permanent resident of the United States. You can still be subject to inadmissibility even with a green card re-entering the United States in certain instances. If you have certain crimes, if you're outside the U.S. for more than 180 days, etc. Okay? So that's my answer to you. Joel Cinto, great to see you. I see the question here from Vicky Morantes. You say, my husband has been in ICE custody for 7 days now. What can we do to speed up the process? I am so sorry. All right, I am so sorry about that. That is absolutely a nightmare. That is a horrible, horrible situation. I hope that you have an attorney. I hope that they are a good attorney, and I hope that they are fighting this. Here's the truth. I am fighting a detained case, and my client is approaching 1 year in ICE custody, and it has been horrible. All right? And like ICE custody right now and immigration detention right now is horrible. My client was denied bond because of this new memo that has come out. We are fighting for his individual hearing. Listen to this, folks. My client's individual hearing was scheduled yesterday. We were expecting to win our asylum case yesterday, crossing our fingers, knock on wood. We have a well-prepared case. We get to court yesterday. Our client's detained. They've been detained now 9 months. We get to court. The judge comes in and says, counsel, I'm so sorry, we don't have an interpreter for your hearing today. We've got to schedule it out. We've got to move it out. Our client now, who's been waiting all this time, has to be detained for 1 more month just because the court couldn't get an interpreter in the case yesterday. All right? It's so unfair. It's aggravating. It's a horrible situation. And Vicky, my heart goes out to you and your family and your husband. And the fight is going to need to be on. All right? Because for folks that are in immigration detention right now, it is a horrible situation to be in. All right? That's all I can say about it. That's all I can say about it. And get a good lawyer, fight that fight. If my office can help you in any way, we'd love to do that. But those are tough cases. All right, you guys. Thank you all very, very much for being here. I appreciate each of you. I'm Otis Landerholm Immigration, A.P.C, where we fight for your American dream. Last question of the day. What's the procedure to renew a green card with a misdemeanor? get counsel first, get advice first of whether or not you should renew it. And then the procedure is on Form I-90, which is the form to renew a green card. And some misdemeanors are fine, and some misdemeanors cause big problems. So the question isn't, was it felony or misdemeanor? The question is, did it cause deportability or didn't it? All right? Get that advice first, then renew your green card through Form I-90, as long as it's a sound thing for you to do. All right? Thank you for asking that question. Thanks, everybody, for your participation today. Really appreciate each of you. Make it a great day, folks. All right? If this was useful, if this was helpful, please take a moment, subscribe to our channel on YouTube. We've crossed 20,000 subscribers in YouTube. We're going for 30. All right? We'd love your help. So thank you so much for being here. Really appreciate you. Make it a great day, and we'll see you next time on our next episode of the Empowered Immigrant Live. Thanks so much. Take care. Bye-bye.